Good afternoon. Well, yesterday you saw the situation outside Luthuli House. A truck belonging to the Sheriff of the High Court was trying to attach some of the assets belonging to the ANC. A High Court and then the Supreme Court of Appeal had ruled that the ANC owes the company, Zolweni Investments, over 100 million rand for campaign regalia created for the 2019 elections. The ANC says the Sheriff moved in too early and that it's going to the Constitutional Court to appeal the last ruling in this case. So, how does it all work? Advocate Mark Morgan is the chair of the South African Board of Sheriffs. Mr. Morgan, good afternoon to you and thank you for your time. So as I understand it, the job of a sheriff is to implement a court order. So if a court says someone owes me money, I don't go and get the money myself, the sheriff gets the money. How does it work?
Good afternoon, Stephen, and the viewers at home. So thank you for the questions, Stephen, and for inviting us to clarify matters on this pertinent topic currently in our country. Well, yes, sheriffs, you're correct. Sheriffs are officers of the court, as they are known. In fact, in simple terms, they are the law enforcement officers of the civil justice system. And what that means is that a sheriff is bestowed the task or the obligation to execute on all court orders, civil court orders, that emanate from any court in the Republic of South Africa, being a lower court, magistrate's court, or the superior courts, meaning the High Court, or any other court above. Most importantly, Stephen, sheriffs don't only enforce judgment debts or monetary judgments, they also in certain instances enforce judgments like interdicts or declaratives in the form of where a court now tells them to do something. For example, an eviction, where an applicant would go and apply for an eviction order and the court would grant the order. If it's a commercial premises, it's easier. If it is residential properties, primary residence, obviously, which implicate the right to housing per the Constitution, then a person in that instance or a person who seeks to evict must get a special court order declaring the property specially executable. But then what then happens is that in the court order, the court would normally then place an obligation on the sheriff to say the sheriff must go and execute on the order. Okay. Like traffic officers who are law enforcement officers on the roads, like policemen who are law enforcement officers in the criminal justice system, now sheriffs are law enforcement officers in the civil justice system. And what we've seen pan out here, for example, in the past few days, is nothing that actually does not happen. It happens in the ordinary course and then into the day-to-day lives of a sheriff. Okay. In fact, I think this one got most of the hype because it involves one of the high-ranking political parties in our country. Okay. However, be that as it may, sorry, Stephen, for the long answer, but be that as it may, what the sheriff would normally do is they get the court order and they enforce on the court order. If it's monetary, like in this instance, the first thing they do in terms of the law, and this is in terms of the Superior Courts Act and the Magistrate Court rules, which are acts of parliament or rules of court, they must go and enforce and assist the court or assist the judgment creditor, they call, in recouping the money he or she is entitled to.
Okay, so if someone arrives at my door and says there's a court order against me, the sheriff would have a copy of that court order. You would never arrive without the court order. You would have the court order that says, Stephen Curtis, you have to pay up.
Yes, but most importantly, Stephen, it's not just the court order. So the court would grant firstly a court order. And before the sheriff can even execute on the court order, the sheriff has to, or the judgment creditor, who is the party that seeks to now have the judgment enforced, needs to go to the court and obtain something that's called a writ of execution. It's another document which then now allows, in fact, that's the document that instructs the sheriff to go and enforce on the property. And usually when the sheriff comes to your door, the sheriff must come with a court order as well as a writ of execution, which will clearly have the registrar's stamp on it, and it would be granted through the registrar's office or the clerk of the court in the magistrate's court, which then, in the body, if you read it, it then instructs the sheriff to go and attach, and in certain instances it says go and attach certain movables that amount to the amount that is owed. And then in certain instances it goes further. It doesn't say don't attach only. It says go and attach and remove which would mean that basically an attachment and a removal, just by way of distinction quickly, is if the sheriff attaches, they just come to the premises, they identify the movable assets, because in terms of the law, you have to first execute on movables before you go on immovables. Yeah. So they'll first go and look in the premises what movables are there, create an inventory, as they did in this case, which inventory would try and have the movable assets satisfy the judgment debt. In the event that the movables, which are your furniture, there are certain movables that are excluded in terms of the law, and those are gazetted in the uniform rules of court as well as the magistrate court rules, which are mainly the basics that anyone needs to survive on. For example, a fridge, a stove, and all of that, bedding and sheets. They can't attach that. Sure. They first attach, and then thereafter they execute a remove and then sell at a public auction.
I'm sorry, Mr. Morgan, there's a lot to get through. So a sheriff does nothing without the court order. A judge and a registrar has to have stamped it. Without that, the order is nothing.
Yes.
Okay.
Yes, especially if it's a movable property, mostly if it's residential property of an ordinary person, their primary residence, they have to get a special order that declares the property specially executable.
If someone refuses to obey, so you come to my house, you say, Stephen, I'm going to take your laptop because you owe money, and I say, you can't come into my house, I'm bigger than you, what happens next?
It is a criminal offence to obstruct a sheriff from doing their job, like it is for a police officer or a traffic officer or any law enforcement officer. It is a criminal offence. Where we find it being made an offence in terms of the civil justice system is the Superior Courts Act, Section 46, and the Magistrates Court Rules, Section 82, as well as the Magistrates Courts Act, Section 107. There, it makes it an offence, just that in the lower courts, which I think is something that Parliament needs to mull on, especially in terms of the Magistrates Courts Act, the enforceability and the amounts that have been stated in there. For example, if you go and look at the Magistrates Court Act, it says you'll be guilty of an offence and liable upon conviction to a fine not exceeding 500 rand, or in default payment to imprisonment for a period of not exceeding 6 months, or such imprisonment without an option of a fine. Okay. So obviously, once there's contempt of that sort, it would go back to court. Normally, the initiator in this instance would be the sheriff or the judgment creditor. And in the sense of a Magistrates Court Act, it would, you see, the fine is not that much, it's 500 rand. But in the instance of a High Court order, which is what we've seen in the case that you referred to, when you go to the Superior Courts Act, it says that the person now who's evaded or who's obstructing the sheriff from doing their job will be guilty of an offence and liable on conviction to a fine. It doesn't stipulate an amount, so it can be any amount that the court deems just and equitable, depending on the circumstances of the contempt. And then it says, or imprisonment for a period not exceeding 1 year. So then it puts a cap again to say, you can find yourself in prison, depending on the circumstances again, and it can be for a period of 1 year. Okay. That's the best that we have in our law.
Okay, so someone who obstructs you is breaking the law.
Is breaking the law.
Do you have to pay to use the sheriff? So if I win a court order saying that someone owes me money, do I pay the sheriff or does the court pay you?
No. What happens is sheriffs have been recognized in terms of there's a labor court judgment as independent contractors. Although they are appointed by the Minister of Justice and Correctional Services up until the age of 65, they're independent contractors, so they're basically businessmen. You pay and businesswomen. You pay them directly. However, the fee that you pay them is capped. It's a tariff that is determined in terms of, again, the uniform rules of court or the magistrates' rules of court. And I see now we've gone on to make our scope wider, where sheriffs even do now enforce CCMA arbitration awards and all other perform some functions like as well as serve documents in domestic violence cases, as well as maintenance cases. And in domestic violence and maintenance cases, they're usually paid by the Department of Justice because they're fulfilling a function that they ought to have been fulfilling in terms of the Act. But ordinarily, a judgment creditor, for example, yourself, if you were to go and use the services of a sheriff, you'd be charged through your attorney, and it would be a tariffed amount or a capped amount in terms of the rules of court.
Are there times when a sheriff can't implement an order? And I remember it was a strange case. You may remember it, the Dudu Myeni case. She was supposed to pay 200,000 rand after a very long story. She was declared a delinquent director for her role as chair at SAA. The sheriff had to attach her goods, if I remember it correctly. The sheriff did not take her goods from her house because the sheriff said they had nowhere to store them. So, I mean, how often do things like that happen? It seemed like quite a strange case.
Yes, indeed, that is strange, Stephen, but that's why I'm here as the chairperson of the South African Board for Sheriffs. In fact, we are a regulator in the sheriff's industry. And this is an unfortunate case, I must state. Like many others that we have, we are the regulators of the profession. So from an administrative point of view, there are sheriffs that are still truant out there that do misconduct themselves in a similar way. When a court order is granted, a sheriff must enforce a court order promptly. There is no way that a sheriff can give a judgment debtor leeway. I've always said, or negotiate something in return, or negotiate favors, which is what we've seen recently, where I have a bizarre incident now that's sitting on my table where a sheriff does not want to, the judgment creditor actually complained that the sheriff has refused to execute on an order because the sheriff is of the view that it is a government institution and the sheriff is a card-carrying member and they can't go and seize simply because they're a card-carrying member. That is misconduct, plainly. It cannot be the case. Court orders are there to be enforced. When a court gives an order, irrespective of the party, it has to be enforced promptly and timelessly. So that is why we are there. In those instances, then the judgment creditor is encouraged to lay a complaint against the sheriff. It's normally takes in the form of an affidavit to the South African Board for Sheriff, where we deal with these matters independently, impartially, without any fear, favor, or prejudice. And what I've seen in this case, since my term of office, which is 2.5 years now, we've not dealt with these matters lightly. What normally comes is a suspension, a request for suspension to the minister, or a removal to the minister, which in most instances, in fact, which we've asked for, they have been acceded to. So if you go back to that case of Ms. Myeni, I think it was brought to our attention, and as soon as it got to my attention, the next day there was we were informed that the sheriff was attaching and the assets were being auctioned off to realize the judgment debt, which was against the state once again. So there, I think it was more of a thing where a sheriff and having to enforce their duties, I don't know whether they got intimidated or because they believe they're card-carrying members, there was a conflict of interest, in all honesty.
It must happen sometimes where, say, for example, I owe someone money, there's been court processes, the sheriff arrives, and I say, I see your court order, but I can confirm to you that I'm appealing the judgment. Now the sheriff has to make a judgment call, right? The sheriff has to decide, do they accept my word? Do they accept the word of my attorney that I'm actually, appealing? Do they need to see a legal document? You know why I'm using this particular example, Mark. But, so what happens then? Because now the sheriff has to make quite a difficult judgment call, and the sheriff is not a lawyer. I mean, they are a lawyer, but they aren't a lawyer.
Yeah. Once again, and you're right, most of the sheriffs are not lawyers. It's a minority that are lawyers. Where, in fact, in terms of the Act, they should have a minimum qualification of 3 years. However, I think that's how we found them, and we're looking at it in that light. But you're right. The word, a person's or judgment debtor's word is not sufficient. They have to show you a legal document, which would be, if they say we are appealing, it would be a notice of appeal, duly signed, stamped, and served on either party. Then in law it would constitute delivery, if you call it that way. So once there is a notice of appeal that has been delivered, then the sheriff then, in terms of the law, cannot execute or continue to execute on the court order that was granted. In fact, in legal terminology, we say the order is stayed pending the appeal of the order. That obviously, there is case law to that effect. Our courts have been clear to say once a judgment debtor has lodged an appeal, the judgment creditor and all other parties ought to respect that right, because it is a constitutional right, one, to appeal, access to court, section 34, and two, it also prevents an instance where, say, the appellate court would have found that the initial court, or the court of quo in legal terms, had erred, for example, then, and it sets aside the court order, then it is not, it's no longer impractical for the order now, for the appellate court's order to be enforced. It means that it would be reversed, and obviously then you have not lost your asset that has now been sold in an auction, or a house that has been sold in an auction, and it's past maybe 3 or 4 owners then, and it would be difficult for you to recoup. So it's a safeguarding measure. However, if the judgment debtor is of the view that you are lodging an appeal solely in order to delay the execution of the court order, they do have remedy, they do have recourse, and that, all lawyers will tell you, is in terms of section 18.3 of the Superior Courts Act, where you bring an application, a special application to the High Court, where you ask for leave to execute on the order pending an appeal. And there's a test that's applied. You show the prospects of success on an appeal and all of that. And if a judge is convinced, then the judge would grant you that order, and the sheriff then, once again, would go back and be given the power to execute now on the initial order pending the appeal. But it's done in very exceptional circumstances. It's not orders that you get easily.
Advocate Mark Morgan, I finally think I understand what you do. Thank you very much indeed, and thank you for the time. Really do appreciate it. Very helpful conversation.